20 ಕೇಸಲ್ಲಿ ಇದ್ಕೊಂಡು ನನಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇಲ್ಲ, ನಾನು ಬಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಅದು ಬೇರೆ ಪ್ರಶ್ನೆ. 20 ಕೇಸ್ ಸ್ವಾಮಿ FIR ಇದೆ, ಬೇಕಂತಕ್ಕೆ ನನ್ನ ಮೇಲೆಲ್ಲ ಹಾಕ್ತಾರೆ, ಅದು ಬೇರೆ ಪ್ರಶ್ನೆ. ಕೇಸ್ ಇದ್ಕೊಂಡು ಕೋರ್ಟ್ ಮುಂದೆ ಹೋಗಿ ನಿಂತ್ಕೊಂಡು ಟ್ರಯಲ್ ಫೇಸ್ ಮಾಡಿ ಪೆಟಿಷನ್ ಅಲ್ಲಿ ಏನು ಇಲ್ಲ ಅಂತ ಬರೀತೀವಿ ಅಂತಂದ್ರೆ, ಇಟ್ ನಾಟ್ ಓನ್ಲಿ ಅಮೌಂಟ್ ಟು ಸಪ್ರೆಷನ್ ಆಫ್ ಮೆಟೀರಿಯಲ್ ಫ್ಯಾಕ್ಟ್ಸ್, ಕೀಪಿಂಗ್ ಅವೇ ಸರ್ಟನ್ ಥಿಂಗ್ಸ್ ಅಂಡ್ ಟ್ರೈಂಗ್ ಟು ಮಿಸ್ಲೀಡ್ ದಿ ಕೋರ್ಟ್ ಅಂತ ಬರ್ದಿಟ್ಟು 1 ಲಕ್ಷ ಕಾಸ್ಟ್ ಆಗ್ತದೆ. ಯು ಡಿಸೈಡ್ ವಾಟ್ ಯು ವಾಂಟ್ ಟು ಡು.
ಪ್ಲೀಸ್. ಸದರಿ ಶಶಿಕುಮಾರ್ ನನ್ನನ್ನು ಅದೇ ದಿನ ಸಂಜೆ 5 ಗಂಟೆಗೆ ನನ್ನನ್ನು ಕರೆದುಕೊಂಡು ಚನ್ನಪಟ್ಟಣದವರ ಸ್ನೇಹಿತರ ಮನೆಗೆ ನನ್ನನ್ನು ಕರೆದುಕೊಂಡು ಹೋದರು. 1 ದಿನ ಅಲ್ಲೇ ಉಳಿದಿದ್ದು ಮಾರನೇ ದಿನ ಶಶಿಕುಮಾರ್ ಸ್ನೇಹಿತ ಪತ್ನಿಯ ಮನೆಗೆ, ಅಂದರೆ ಬೆಂಗಳೂರಿನ ಸೋ ಅಂಡ್ ಸೋ ಬಂದೆವು. ನಮ್ಮ ತಂದೆ ತಾಯಿ ನಮಗೆ ಫೋನ್ ಮಾಡಿ ಇಬ್ಬರಿಗೂ ಮದುವೆ ಮಾಡುವುದಾಗಿ ಒಪ್ಪಿ ಊರಿಗೆ ಬರಲು ಕರೆದರು. ನನ್ನನ್ನು ಅಲ್ಲೇ ಬಿಟ್ಟು ಸೋಮವಾರ ಶಶಿಕುಮಾರ್ ಮದುವೆ ಮಾತುಕತೆ ಮಾಡಲು ಊರಿಗೆ ಹೋದರು. ಮದುವೆ
71 ಪ್ಯಾರಾದಲ್ಲಿ ಮೇಲ್ಗಡೆಯಿಂದ 3ನೇ ಲೈನು. ಹೀಗೆ ಸುಮಾರು 3 ತಿಂಗಳ ಹಿಂದೆ
ಶಶಿಕುಮಾರ್ ನಮ್ಮ ಮನೆಗೆ ಬಂದು ಹೋಗುತ್ತಿದ್ದಾಗ ನನ್ನ ಹಾಗೂ ಶಶಿಕುಮಾರ್ ನಡುವೆ ದೈಹಿಕ ಸಂಪರ್ಕ ಆಗಿದ್ದು, ನಾನೀಗ 3 ತಿಂಗಳ ಗರ್ಭಿಣಿ. ಪ್ಲೀಸ್.
ದಟ್ಸ್ ಆಲ್.
She is aged 17 years.
What can be done? Look at 375 6th.
Please, my lord.
Section 375 6th. Kindly read it. IPC.
Please, my lord. They have in fact got married because.
Kindly read. What Murthy?
That I am aware, my lord. I am not disputing that.
Kindly read. Kindly read.
Please, please.
(375 6th).
With or without her consent when she is under 18 years of age. Please,
That's all. Now, if you, I think you are aware of the judgment of the Honorable Apex Court in independent thought. Judgment by Honorable Apex Court in independent thought versus union. If you have with you, well and good. 2017, 10 SEC, page 800. Independent thought versus Union of India.
Please, my lord.
Their lordships have said similar case. They're also wife. Under the age, it attracts POCSO 6. What can be done? Consent is immaterial.
Please. And now she is of 18. She is 18 years of age.
There also, sir, she was the wife.
Please.
Having a sexual intercourse with the wife who is under the age of 18 is what is not contemplated under the POCSO Act, and therefore POCSO gets attracted, and such people must be brought to books under Section 6. In complementary with the Section 4 and 6, 3 and 5 of the POCSO Act, the amendment is also carried out in favor in Section 60 of 375, which was earlier 16 years. So, the set of the decisions of this court as well as the various other Honorable High Courts and Honorable Supreme Court, which were proceeding on the premises that there was the age of discretion above 16 years, will have no significance when we apply the POCSO Act.
Please.
This is my understanding.
Please,
so,
Lord.
A need has arisen now. Probably, in a given case, as a test case, people should approach and knock the doors of the Supreme Court to have a real relook into independent thought, and then Union of India may be directed to consider such of the cases where the love affair and marriage, etc., are there, should stand on a different footing. Unless such a thing comes out, we are bound by what the Honorable Supreme Court says in such circumstances, and that there is no other go. See, 2 things would arise. One is age of marriage. There are some differences with regard to the Muslim marriage. With Hindus, there is no problem. Earlier, if you go by the Hindu Marriage Act, the eligibility criteria for a Hindu girl to get married was 15 years, 1-5. But there was an embargo not to have the physical relationships till 16 years. It would not be considered as a void ab initio. The marriage would not be considered void ab initio.
Please.
It was at the instance of the wife that it's a viable marriage at the instance of the wife. So 16 was the age. Then this Child Marriage Act came. The age is now fixed 18 and 21.
Please, my lord.
Therefore, when the Supreme Court had to apply all these aspects of the matter, they said that Child Marriage Act is a special enactment and it will prevail over the other provisions of the Hindu's Marriage Act. But that did not happen in respect of the Muslim community. There, according to the Quran, the age eligibility criteria for a girl to get married is attaining the age of puberty. Now, Muslim girls are attaining the age of puberty at 12, 13. So the issue came up. There is a problem. In that event of the matter, Supreme Court had an occasion to deal with all these aspects of the matter in the independent thought. You can go through all those things. Their lordships are of the opinion, irrespective of the personal laws. When the POCSO Act has been enacted, the provisions of the POCSO Act will prevail over all other aspects of the matter, including the personal laws belonging to Christians, the Mohammedans, and the Hindus.
Please.
So therefore, when POCSO Act should prevail, all other things that are available defenses would get into insignificance.
Please.
Therefore, a need has arisen. Take this case itself to the Honorable Apex Court, if your client is willing.
Maybe some other case, my lord. This case is
All right. I am not saying any of those things. At least 1 dozen of the cases I have decided in this roster itself about this aspect of the matter earlier also.
Please.
This is the consistent view. See, the whole idea is to see that definition of child in the POCSO Act is up to 18 years.
Please.
Even if it is 17 years, 11 months, 30 days, you can't help it.
Please. Okay.
So people will have to. I had an occasion to deal with similar situation when I was the district judge at Haveri. It was a very peculiar case. Boy is 17 years, 11 months or so. Girl is 17 years, some 9 months or so. They have a child of 6 months. What to do?
Please.
What to do?
And here, my lord, in this case.
And you see, the girl, there will be considered as child. Boy is also considered as child. But since he is the aggressor party, even as per the JJB Act, if he has committed an act of forcible sexual intercourse, he should be tried as an adult with the amendment.
Please. But here the boy, my lord, the accused is 31.
It makes no difference for me. I am only trying to say,
please,
that the victim girl, if she is under 18, because of the words and the object of POCSO Act, I am afraid that this court can exercise any discretion under 439, following that set of judgments where age of discretion was to be taken into account. This is the enactment. We have accepted it.
Please, my lord. Henceforth, the boys will have to be careful.
Scope of 439 is narrowed down. Further, you see, a person charged with 302 IPC will have a label of innocent on his forehead. See section 29 of the POCSO Act. Kindly read it. Kindly read it.
Presumption as to certain offences. Where a person is prosecuted for committing or abetting or attempting to commit any offence under section 3, 5, 7 and 9 of this act, the special court shall presume that such person has committed or abetted.
Why are you going so speed?
I'm sorry.
It is not Konkan Express. Shall presume is the word.
Please, please.
And please, I need not tell Murthy as to what is the difference between may presume and shall presume. Is it not?
Please,
so there is no option left over for this court. The wordings are so strong, and that is for the set of offences only. When the punishment sections are told there, 5, 7 and 9.
Yes, 3, 5, 7 and
Offense
9.
sections are 3, 4 and 8. If you see this section 29,
Yes.
they have mentioned a category of offences.
Yes, 3, 5, 7 and 9.
Correct. Now what will happen? 3 is the punishment, 3 is the offense section, 4 is the punishment, 5, 6, 8 and 9. These are the situations. So they have given for set of offences, a presumption is made under the act itself. That court shall presume, you can now continue. Shall presume what?
Shall presume that such person has committed or abetted or attempted to commit the offence, as the case may be, unless the contrary is true.
Now you see what the label says. You are guilty is the label, not the you are innocent. You will have to remove this label, no?
Please, my lord.
Placing something on record, and from the other material, including the 164, the material that is available is, it's a case of a law affair.
Please.
Independent thought says, no, you can't, that could not be a defense at all. And we are at the bail stage. What is it that I should do?
My lord, in fact, if I may pursue your lordship, as far as bail is...
Then also on 30, you can see it's a twin presumption. It's a twin presumption.
Please. Please, my lord, but as far as...
Which is complementary to section 29.
Please.
Mental condition is that you committed an offense under 29, in the POCSO Act. Mental condition to be looked into. Just because she is my wife, we had an affair, therefore I had the physical relationship, would not be of much relevance while considering the aspect of the matter. Again, you can see 30. For all offences under the POCSO Act, 29 is restricted to set of offences.
Please.
So for 30 is concerned, the mens rea, actus reus, the sine qua non for the completing the offence. One aspect is straight away made as presumed to be present, that is mens rea. Actus reus is there because she is 3 months pregnant as on the date of giving the state.
Please. In fact, my lord, if he is granted bail, then because they have not, my instructions are, she has not aborted the child.
What to do? What to do? See, those are all the considerations maybe in the trial. There again, Honorable Supreme Court has cautioned many times, the question of marriage, etc., will not take away, efface the criminality.
Please, my lord, but
I leave it at that, because this is not the stage for this court to express any opinion on many.
Please.
You have two options. One is you withdraw this petition and then pursue with the trial and then take whatever the defenses. Otherwise, I may have to observe few things while deciding the bail itself.
My lord,
You talk to your briefing counsel. I'll release it on Monday.
please.
Memaki case number details put. Adhan birth close martin. Nothing doing. If you willfully, knowing fully well that you are party there and then say that your instructions are there, I am a law-abiding citizen, no case are pending. That itself is suppression of material facts, which would disentitle you from obtaining an order. Nothing doing. 20 case itkondu nanತರ ಏನು ಇಲ್ಲ ಅಂತ ಯಾವ ಬಾಯಲ್ಲಿ ಹೇಳ್ತೀರಿ? Keep your party present on Monday. We will see whether he has instructed you or not. Keep your party present. ಕರೆದು ಇಲ್ಲಿಂದಾನೆ ಕೊಟ್ಟು ಕಳಿಸ್ತೀವಿ. ಇಲ್ಲಿಂದಾನೆ ಕರೆದು 50 ಕರೆದು ತಗೊಂಡೋಗಿ ಅಂತ ಹೇಳ್ಬೇಕಾಗುತ್ತೆ. 20 ಕೇಸಲ್ಲಿ ಇದ್ಕೊಂಡು ನನಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇಲ್ಲ, ನಾನು ಬಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಅದು ಬೇರೆ ಪ್ರಶ್ನೆ. 20 ಕೇಸು ಸ್ವಾಮಿ FIR ಇದೆ, ಬೇಕಂತಕ್ಕೆ ನನ್ನ ಮೇಲೆಲ್ಲ ಹಾಕ್ತಾರೆ, ಅದು ಬೇರೆ ಪ್ರಶ್ನೆ. ಕೇಸ್ ಇದ್ಕೊಂಡು ಕೋರ್ಟ್ ಮುಂದೆ ಹೋಗಿ ನಿಂತ್ಕೊಂಡು ಟ್ರಯಲ್ ಫೇಸ್ ಮಾಡಿ ಪೆಟಿಷನ್ ಅಲ್ಲಿ ಏನು ಇಲ್ಲ ಅಂತ ಬರುತ್ತೀವಿ ಅಂತಂದ್ರೆ, ಇಟ್ ನಾಟ್ ಓನ್ಲಿ ಅಮೌಂಟ್ ಟು ಸಪ್ರೆಷನ್ ಆಫ್ ಮೆಟೀರಿಯಲ್ ಫ್ಯಾಕ್ಟ್ಸ್, ಕೀಪಿಂಗ್ ಅವೇ ಸರ್ಟನ್ ಥಿಂಗ್ಸ್ ಅಂಡ್ ಟ್ರೈಂಗ್ ಟು ಮಿಸ್ಲೀಡ್ ದಿ ಕೋರ್ಟ್ ಅಂತ ಬರ್ದಿಟ್ಟು 1 ಲಕ್ಷ ಕಾಸ್ಟ್ ಆಗ್ತದೆ. You decide what you want to do. Don't tell me all those things. My instructions are not there. Keep your party present. If he is not able to come, then I will impose the cost. I'll impose the cost. Sir, read 438 subclass 2, subclass 1 and subclass 2. ಏನ್ ನನ್ಗೆಲ್ಲ ಹೇಳ್ಬೇಡಿ ಇದನ್ನ. ಇದು ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಪ್ರಾಕ್ಟೀಸ್ ಬಾಂಬೆಲಿ. ಇಂಟ್ರೀಮ್ ಬೇಲ್ ಕೊಡೋದು, ಅಲ್ಲಿ ಬಾ ಅಂತ ಕೂಡ್ಸ್ಕೊಡೋದು, ಮಾರನೇ ದಿನ ಐವೋ ಕೊಡೋದು, ಆ ಕಡೆಯಿಂದ ಬಿಟ್ಟು ಕಳಿಸ್ಬಿಡೋದು, ತಗೊಂಡೋಗಪ್ಪ ಅವ್ನ. ನಾನು while granting the interim bail, presence of the petitioner be made available before the court ಅಂತಿದೆ, ಓದಿ. ಅದೆಲ್ಲ ಆಯ್ತು ಬಿಡಿ, ಸಾಕಲ್ಲ, ಬನ್ನಿ ಅಂತ ಹೇಳ್ಬೋದಲ್ಲ, ಹೇಳ್ಬೋದಲ್ಲ, ಅಲ್ಲ ಹೇಳ್ಬೋದಲ್ವಾ ಅಂತ ಕೇಳ್ದೆ ಅಷ್ಟೇ ನಾನು. ಇಲ್ವಾ? ಏನ್ ಓದಿದ್ರಿ ಮತ್ತೆ ನೀವು? ಅದಕ್ಕೆ ಮುಂಚಿಂದ ಓದ್ರಿ, ಮುಂಚಿಂದ ಓದ್ರಿ, ಎಲ್ಲಾರು ಕೇಳಿಸ್ಕೊಂಡಿದ್ದಾರೆ, ಇನ್ನೊಂದ್ಸತಿ ಕೇಳಿಸ್ಕೊಳ್ಳಿ.
Direction under subsection 1. It may include such condition in such direction in the light of the facts of the
ಓದಿ. ಅದಲ್ಲ ರೀ, ಇವಾಗ ಓದಿದ್ದನ್ನ ಓದ್ರಿ.
When the court of sessions makes a direction under subsection 1.
It may include.
Grant me.
It may include.
It may include such condition in such direction in the light of the facts of the particular case as it may include.
ಎಲ್ಲ ಅರ್ಧಂಬರ್ಧ ಓದಿದ್ರೆ ನನ್ಗೇನು ಓದಕ್ ಬರಲ್ವಾ? This is not the way to make a submission before the court. It can direct that he should be present, made available to the investigation agency, including appearance before the court. ಬನ್ನಿ, ನಾನು ಬರೀತೀನಿ ಈಗ ಆರ್ಡರ್. ಕೀಪ್ ದಿ ಪೆಟಿಷನರ್ ಪ್ರೆಸೆಂಟ್. ಬರೀಲ್ಲ, ಬೇಡ ಅಂದ್ರೆ ಬಿಟ್ಬಿಡ್ತೀನಿ. 20 ಕೇಸ್ ಇಟ್ಕೊಂಡು ತಾವು ನನಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇಲ್ಲ ಅಂತ ಬರೀತೀರಿ, ಬರ್ಕೊಳ್ಳಿ. ಹಾರ್ಡ್ ಶ್ರೀ ಭರತ್ ಕುಮಾರ್, ಲ್ಯಾಂಡ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ಪೆಟಿಷನರ್. HCGP submits that the petitioner is having criminal antecedents. He is involved in as many as 20 cases. First, petition is silent about the petitioner being an accused in 20 cases. First, counsel for petitioner submits that he has no instructions about the antecedents of the petitioner. In order to ascertain the correctness of the statement made by the land counsel for the petitioner, petitioner is directed to be present before this court on 15th of March at 2:30.